this. Susan, do it on the main page. I'm happy to give them publicity.
I am.
You're being kind enough. We normally do some on the gym page. Sometimes we do it to everyone. We'll do it to everyone.
And we're broadcasting.
Okay, guys and girls, let's wait for this audience to build up. I am so pumped and excited. So pumped and excited. What I'm going to do is I'm even doing a photo here straight on Instagram here, and I'm going to put it on there at the end of this, because on the other side of the screen, we have Lisa Jemmeson and Steve Fisher, who are from Fisher Jemmeson or Jemmeson Fisher. It's Jemmeson Fisher, isn't it?
It is. It is.
It is. And these guys here, I think, are the intel of the real estate industry, because they're across the stimulus package that has come across. And one of the big things that we're going to chat with Steve is this confusion about the $1,500 announcement, which I think was on Sunday night, $750 a week. And people are confused. Does it apply to me? Can my staff get it if you're a business owner? What if I'm debit credit, commission only? All that we're going to unpack. We're also going to touch on other stimulus and how they can help a real estate office. And also Lisa, who is in litigation. And you're on the board of what, Lisa? You told me before, you're on the board of?
On the liaison committee with NCAT.
Okay, so, and can you tell everyone what is NCAT for those that don't know?
The New South Wales Civil and Administrative Tribunal. And so that's relevant for agents in the residential space and also retail space.
Okay, and that's important because there was a guy this morning, Lisa, at the cafe. I went to pick up a coffee, social distance, of course, right? Picked up a coffee, and I hear this guy say to the other guy, his mate, I'm finishing off work on Friday. And the guy goes, why? And he goes, oh, I've just been able to manage to do it, and I reckon I'm going to get away with not having to pay any rent for 6 months. I was about to throw my coffee at him because I thought to myself, here's a guy, he sat there, he watched something about, don't worry, you can't get evicted. He's come up with a quick calculation in his head, I don't have to pay rent, right? And that's not quite true. And at the moment, property managers are stressed, Lisa. They're pulling their hair out. They don't know how to respond, and you're going to help us. Firstly, understand what the law is, and secondly, a few suggestions on how to handle tenants that are ringing up saying, I can't pay the rents.
Yeah, okay. So look, I think the first important thing, start with the premise that a residential tenancy agreement or a retail lease, but if we look at a residential tenancy agreement first, it's a contract. And so similar to a mortgage contract, parties have obligations, and one of the obligations on a tenant is to pay the rent. So if they don't pay it, and NCAT are directed not to terminate tenancies for 6 months, the debt still accrues. So it's madness to think that a tenant can sit there for 6 months and the rent will just be wiped. It won't. It'll just mean at the end of the 6 month period, there'll be an application to NCAT and the entire debt will fall due. And if that debt is over the monetary limit of NCAT in the division, then it'll be litigated through the court system. So the tenants need to keep paying.
Okay.
If we talk about the mechanics of it, though, what we're saying is you need to have a conversation with your tenants about what they can pay. And we've been asked, today in particular, we've had 3 or 4 calls from property managers saying, is there a checklist of things that we should be asking or to find out about what tenants can actually pay? And there's not a checklist, and we'd probably discourage a checklist because if you look at what happened when the tenant originally went in, they would have filled in an application form. And so that would have had, well, where do you work and how much do you earn? And what outgoings do you have? You should work off that form. So you should say, look, when you went in, you're earning $150,000 a year. Where are you at now? Have you been stood down? Has your employer qualified or gone on to the job keeper type arrangements? What can you actually afford to pay? And try and organise a payment plan. And what's super important is that there's a difference between suspending rent, reducing rent, and a payment plan. Just before we come on, Tom, I phoned a contact of mine at Ebm Insurance, and property managers are probably well aware of EBM, because a lot of agencies push their landlord protection insurance policy. And I spoke to him about it from his perspective, and on their website, under their landlord protection page, you can go in and they warn agents, and I want to stress this to everyone who's listening, that if you reduce the rent or you make an agreement that they don't have to pay it, the policy isn't going to cover the landlord. And that's on there. So all these people that are doing those two things, I'd really like them to hear this and heed that. And as I say, you can go onto their website and download it themselves after they've finished watching this. But just we would like to say, be very careful about making agreements that could negate the policy.
Okay, extremely useful advice to every property manager and every landlord that's watching this. Essentially what you're saying is the likely potential of an invalid policy when you alter the rent that a tenant is paying. Whilst we're talking about that, Lisa, I had a fair few people ask me in the last 2 days, I should have had landlord insurance. Does landlord insurance cover what has happened with with virus? Like, does landlord insurance cover that?
Okay, so the very latest, as of about 15 minutes ago, when I spoke to EBM, they have referred this off to their underwriters, and they don't have an answer just yet. But what they are recommending to the industry, and you'll see this replicated through other policies as well, is that you follow the standard procedure. Now, one of the anomalies is that if an agent issues a notice of termination, it's not actionable. So what I mean by that is, if you issue a termination notice because a tenant stops paying rent, you've got a certain time period to apply to the tribunal in your state. So it might be VCAT or QCAT or NCAT here in New South Wales, and you litigate on that termination notice. The tribunal, well, certainly in New South Wales, they won't accept those applications. So they're not going to be actionable. But EBM, the landlord insurer, are saying, we want agents to still issue the notice. And the advice when property managers go in and have a look on their website is, if you issue the notice and if NCAT won't accept your application, they're going to still cover the landlord. Now, whether that's for the full period or for a reduced period, we don't know yet, and they don't know because they haven't heard back from the underwriter. But it's very important that they follow the policies or the requirements of the particular insurer to protect their landlords. So that's the big first grab that is, I suppose, new, and the warning going out to the industry. Don't be doing deals that are going to prejudice your landlord's insurance policy for when they go and make a claim.
Okay, whilst you're talking on that, Lisa, can you also confirm things such as a tenant not looking after a place or trashing a place, that doesn't protect them from the 6-month protection of eviction is for to do with not paying the rent, not to doing with other parts of the responsibilities. Is that right?
Correct. So if the tenant is causing serious damage to the property or has threatened a neighbour, for example, the tribunal will hear those applications. They won't hear them face to face, so they'll either hear them on video link or via telephone or on the papers. They will hear those. They will hear matters involving domestic violence, and they will also hear matters where the landlord has caused the premises not to be safe and the tenant makes an application. They will certainly hear those as well.
Okay, another question I was going to ask you is that you make a valid point here, and that is that you've got a bank that have basically said that they might consider freezing payments, but they're still going to get their money. And in addition to that, they'll probably even do a little bit better because they'll get interest on interest, right? So that stakeholder there. Then you've got a tenant, and if you gave a tenant a reduction, the tenant would win out, and the only loser out of the three parties appears to be the landlord in that scenario. But what you're saying is an intelligent way is to work out a payment plan, and not necessarily a reduction plan, but a payment plan to help with cash flow. Could you expand on that a bit? Okay,
so if a tenant was paying $2,000 a week before all of this, and now they can only afford to pay $1,000, you would enter into, or you'd write down the terms of it, of what the tenant can pay, and that's done on an individual basis after the property manager has had a look at their original application, and there's an agreement that they will pay a certain amount per week, and then after a period of time, they might then increase to $1,200 per week or $1,500 a week, but the debt never goes away as such. It's just what the tenant can afford to pay. This will be very relevant at the end if you have to terminate the tenancy, because the tribunal is going to look for and ask the question of property managers, was there a payment plan entered into? What did you do to try and support the tenant through this if they're going to terminate the tenancy? Because there's still going to be a reluctance, I think, to kick people out of premises, because not necessarily everyone is going to get the $1,500 a fortnight. We've heard lots of situations where people are casual, and so they're not going to meet the requirements because they haven't worked in the business for the requisite period. And strangely enough, we've got employers that are saying, I'm not going to register for JobKeeper. I'm not interested in it. So there are still going to be people that are caught out and then are going to have to be going through Centrelink. But the big thing is sitting down with tenants and trying to work something out so that money consistently is coming in and you're not going to have this ballooning debt at the end. Now, just separately, if you do have a ballooning debt at the end, you're still going to have to go to the tribunal to have the tenancy terminated, but then you may be litigating through the court system to recover it if it's over the jurisdictional limit. Now, depending on your policy of landlord insurance, a lot of landlord insurers will cover up to $5,000 in legal fees. So the property managers will be able to send it out and actually have a lawyer recover the debt or get the orders of the court to recover the debt.
Got you. Okay. Lisa, while we're on PM, can we stick, Steve, is it okay if I just stick with PM until, can I just, a couple of things. A question has come in and we haven't touched on, is there anything you want to add on the commercial side of tenancies, commercial tenant, commercial landlord? I've got a question that's come here. In case of commercial tenants, would it be fair to charge interest for late payment? If you waive that, could it affect the lease and rights of the landlord if you waive that? Okay, so the first thing is to note, we've got to be very careful about differentiating between a retail tenant and a commercial tenant. So retail tenancies are very heavily regulated like residential tenancies. Yes. Commercial tenancies are not. So you get away with a lot more, I suppose, on a landlord's side in a commercial tenancy. If there was a waiver of any right, it should be done without prejudice to any rights beyond that particular point in relation to a commercial tenant if they were going to do that. Now, having said that, most commercial leases have
penalty interest clauses for late rent, and most agents don't enforce it or never charge it. So I don't know how big or how relevant it actually is in the marketplace,
Right.
but it is a right. And yes, you could do it, but you would the landlord would reserve their rights in relation to future interest beyond a certain date.
Okay. If a property for sale is tenanted,
Yep.
does the tenant have the right to refuse entry if the correct entry notices are given and social distances measures adhered to? That's a tough one, isn't it?
Well, let's go back to basics. When you give a lease to a tenant, you give them a leasehold interest in your land. Okay, so you've got a fee simple interest as the owner, and you give a leasehold interest. Now, that leasehold interest is a big deal. The only person who outranks a tenant for entry is a mortgagee in possession. So it's that interest that they take is to the exclusion of all others. So the tenant could say, go away, and if the agent tried to enter, because they have exclusive possession, which is one thing that differentiates a lease from a license, and like a hotel room or an Airbnb, because they have exclusive possession, if the property manager or the agent stayed on the premises, then potentially it could become a police matter because you've been asked to leave the premises. Now, one of the questions I saw pop up earlier on Facebook was in relation to I've got a tenant and the property's been sold. It's on an expired lease.
Yes.
And the tenant doesn't want to move out. And
yes.
What are we going to do in that situation? If this is an unconditionally exchanged property and the correct notices were issued and the tenant fails to vacate, although it's not expressly written in the guidelines that have come from NCAT, my view is that they would accept that application. And the reason for that is because you've got a separate contract with a vendor or purchaser that could potentially be set aside to the detriment of the landlord. So it is likely that they would hear those types of applications with supporting evidence of the exchanged contract, possibly something from the party's solicitors, and stating that it was sold with vacant possession. And if we can't give vacant possession, then potentially the purchaser would have the right to terminate that contract because the vendor can't give the purchaser what they bargained for.
Okay. Very good answers. You're very concise. I like that.
Oh, God.
Right. What evidence, Lisa, again, what evidence, if any, does a residential tenant have to provide their property manager in order to either stop paying rent, well, we've sort of gone to either stop paying rent completely for 6 months or to pay a reduced rent? So I suppose what they're saying is what evidence, and yeah, we've sort of covered that. You
got to go back to the original application form. You've got to have a conversation, but we're not about reducing rents. We're just entering into payment plans to manage it, the existing rent and the terms of the existing contract. There's some other stuff just around it before we move off that point. You've got break fees and leases. So if it's just dismal and there's no chance that the tenant's going to be able to pay their rent, it may be an extraordinarily high rent, then a tenant can utilise the break fee provisions within the lease. Now, they've just changed in New South Wales. They're capped at 4 weeks. So if they're 25% into the lease term, they're capped at 4 weeks and they go all the way down to 1 week. That may be something that a property manager would want to raise with the tenant and say, do you want to just break your lease? And we'll try and get someone else in there. And then they can walk out. It doesn't affect their credit rating. They're not going to be listed on ticker or the like if they do the right thing. But that's one mechanism that exists within the legislation that they could utilise their break fee provisions if it's just hopeless and you draw a line in the sand and say, let's not just let this go for 6 months. Let's get on to it now. It's not going to work.
Okay, this question here. If a tenant approaches a real estate agent and or a landlord and tells them they cannot pay the rent due to financial hardship, etc., due to the coronavirus pandemic, then the landlord and or real estate agent must attempt to negotiate a civil agreement in what can be afforded during these pandemic times. Well, this is more of a statement than a question. If a civil agreement cannot be reached, so let's assume you have a conversation, right? And at the end of it, you just say, no, man, that ain't going to work for me. And the agent says, well, that ain't going to work for my landlord, right? What do you reckon you do then?
Well, then the tenant, and if they'd offered a very low rent, so if we use $1,000 a week and the tenant says, look, I'm going to pay you $200 a week, and it's not accepted on those terms, if the tenant then just paid by direct deposit $200 a week, you don't have an agreed payment plan, but you've got a tenant chipping away at a debt. A termination notice would issue that you couldn't necessarily action, and hopefully your landlord has landlord insurance, and landlord insurance with a preferred policy provider and not a bank provider or some of the other ones that stop at 6 weeks.
Right. Okay. So everyone that's watching this, I'd love you to do me a favor and actually press the share button on this video. And the reason why is I actually think, and I know that we're going to probably end up getting 70, 80,000 views of this. And the reason I say it is I actually think part of the issue is tenants need to be educated as well. So maybe just put down on the heading some useful information for tenants to understand the best way to move forward if you have got hardship. Do that and press the share button, because I actually think a lot of the times it is basically because of lack of information that people jump to conclusions, right? So, Lisa, one more other question here, and it's come in just live. I have a warrant to evict a tenant due to rent arrears. The tribunal hearing was on the 9th of the 3rd, and the tenant needed to be out by the 23rd of the 3rd. They haven't had the sheriff's office, and the sheriff's office has advised that they have but all evictions on hold indefinitely. Yeah, well, yeah.
And the warrants expire as well. Depends the orders that you've got. So again, in New South Wales, you've got what we call pay and stay evictions, which means that if the sheriff turns up with the warrant to execute to evict, if the tenant pays some money, the term is some money, it doesn't have to be all of it, the sheriff is charged with the authority to say, I'm not executing the warrant. So if you could get them to execute it and they paid some money, you may still lose it. But as I understand it, the sheriffs are not going to be enforcing any of those warrants to terminate anyone. In which case, the property managers followed the correct process. And again, we hope there's landlord insurance.
Okay, you've said that a few times.
I know, because it's a catch-all. It's exactly for these situations, because, I mean, whoever could have thought that you would have a government saying we're not going to terminate tenancies.
Okay, so by the way, any person that's watching this video right now and as impressed as what I am with the concise and clear and fairly confident manner of answering my questions, if you need any help, the firm, by the way, Susan, if you don't mind, would you put in the comments section the name of the firm, Jemmeson Fisher, and also their contact details, because we'd love you. We'd love you to pick up some business as a result of your kind time of sharing your time with us, right? But I'm pretty sure that you've got a fair bit of business this last few days. I would envisage the calls have been coming left, right, and centre from clients. So, Steve, can I come over to you, because it's a holistic firm where you've got legal, you've got your accounting, and I believe you do from start to finish trust accounting and also the general accounting. I want to touch on, if I can, with you and talk about, particularly I want to talk about this, is it called JobKeep? Is that what it's called? Job keep allowance.
Job keeper.
Job keeper, right? So firstly, what is the job keeper allowance?
Okay, well, the job keeper allowance is a recognition by the government that they want the employer to maintain the relationship with the employee over the next 3 to 6 months. And in recognition of the employer maintaining that relationship, they will pay the employer $1,500 per employee per fortnight, which the employer then will distribute to the employee.
Okay, and this is available to people that have been laid off last week to get them back into the business, reinstated, and it's also available to current employees in that business. If they meet, the business have to meet certain criteria, but don't they? Like they've got to drop business, isn't it?
Sure. So in relation to the employees, the employee must have been employed at 1 March.
Right.
And the employee at the current position is still an employee, whether it be because they are attending work or they are stood down but still considered to be an employee, or they are on leave without pay. They're still considered to be an employee. So they, via their employer, will be eligible for the job keeper allowance.
Okay, so let's assume you're on $2,000 a fortnight. You get $1,500. The employer can say, "Hey, come back to work. I'm going to give you $1,500," or they might top it up. They might actually say, "I'm going to top it up and give you another $500, so you're going to keep working." That's how it works. I presume it's also taxable, isn't it? The $1,500 would be taxable.
That's correct. It is taxable. So in the hands of the employee, it's taxable. So there would be pay-as-you-go withholding by the employer, which is approximately of the $1,500 is roughly $200 out of the $1,500.
Okay, Steve, can I ask you, what about salespeople? You know, and salespeople are employed in a business, some of them on debit credit. There are people that are contractors in their own right. Can we just unpack, you know, how it relates to a salesperson who's a commission-based type person?
Yeah, sure. I was listening to Peter Switzer earlier, and he quite rightly made the comment that the package that they've presented 2 days ago doesn't give us the information that we need to properly unpack these unique type of arrangements where we have debit credit, where we have commission only. What we can do is assess the position prior to the JobKeeper allowance, a subsidy being issued, and then look at it, how is that employment arrangement changed, and how is it then changed as a result of receiving the $1,500? So if you take the debit credit person to begin with, and if we use some simple numbers, the debit credit person is on a wage of $1,000 a week, and they are also required to write $50,000 a quarter, $200K a year to meet their requirements under their debit credit arrangement. The employer is already established via the employment agreement as to the fact that if I am paying as an employer $1,000 a week, then you need to meet your targets. If you meet your targets, then we talk about commission later. If the employer is now getting $1,500 a fortnight for those employees, then the employer needs to recognise that they are no longer paying the employees $1,000 a week. They're actually paying them $250 because they're doing a top-up.
Right.
So from a debit credit perspective, it's not a $2,000 debit every fortnight. Because you are receiving $1,500 from the government, it's a pass-through arrangement. The cost to the employer has actually only been $500, which is the difference between the $1,500 and the $2,000. Again, I must stress that this hasn't been, the legislation hasn't even gone to Parliament yet. Nobody has actually provided that level of detail, but from what we have seen in the government's responses to queries that have been raised, we believe that the most likely outcome will be that the debit that is raised against a debit credit salesperson will be the net debit, being the net cost to the employer after the 1,500.
Got you. Okay. Okay. I'm thinking, is there anything you want to add to that about PAs? We can work that out. Property managers, we can work that out. Contractors?
Contractors, we'll separate the two between independent contractors and commission only.
Yes.
So the critical criteria from an employer perspective is, are they an employee? Debit credit, clearly an employee. Commission only is generally an employee. If they're commission only and they're not an employee, then they're an independent contractor. So the arrangements in relation to a commission only employee will be the same as they apply to a debit credit salesperson. And if you tease that out a little and you look at, well, what is the arrangement today prior to this, not today, last week, prior to the job Keeper Allowance being announced, the employer and the employee on a commission-only arrangement had determined between them two in their employment agreement what the cost for the employer was to run that business. If the employee now receives $1,500, which is a pass-through arrangement from the employer's perspective, the employer has received no benefit from that. All they've done is pass the funds through. If they were on a 50-50 split, our view, and we've been throwing this around the office for the last few days, is that should not change, because the employer has suffered no detriment as a result of the 50-50 split and the salesperson continuing to make sales, other than the fact that there may well be a drop-off in sales.
Got you. Okay.
It really goes, Tom, back to our old days, which is employers entered into debit credit and commission only on a desk cost basis. And they assessed the percentages that they would be paying and their expectations of their employees as to what the cost to them was going to be. If the cost to them, or desk costs, or the business costs, it no longer involves a $1,500 payment that is flowing through from the government via JobKeeper allowance or subsidy, then that needs to be reflected in the debit credit arrangement.
Okay. I'm going to hop on here and have a quick look, because those questions coming in, and what I'm going to do, geez, we're not going to get through all these questions. We're not going to get through all these questions. This
is there anything salacious or juicy for us? And pick those ones out.
Yeah.
No.
Let's have it. I read the JobKeeper payment will be paid retroactively. I think he means retrospectively, by the ATO at the end of April. Up to what date does the ex-employer have until to reinstate an employee and receive JobKeeper payments?
Yeah, that's a great question. So the government's announcement meant that from 30 March, last Monday onwards, they were making JobKeeper payments available to employers, but they have also announced that they are paying those $1,500 supplements in arrears every month. So every month you will advise the ATO, because the ATO has the arrangements in place already with the employer via the BAS. You will be advising which employees satisfy the JobKeeper subsidy and for which the employer has paid, and then the ATO will give you the supplement.
Okay.
But that supplement won't commence until, the first supplement won't commence until 1 May, and it will be paid monthly in arrears thereafter.
Can a contractor claim the JobKeeper allowance for themselves?
Yeah, okay. So that brings to the other side, which is the independent contractor arrangement. An independent contractor is assuming that they've entered into the correct arrangements with their employer, but they're not their employer.
With the agency.
With the agency. As long as they have entered into a correct independent contractor arrangement and satisfy all the criteria and have established a separate business and are running a separate business and have their own employees, which is one of the requirements of being an independent contractor, then they, in their own right, would register with the ATO as an employer who would be entitled to receive the job keeper allowances.
Okay. I'm a contractor and a sole trader. Can I claim the job keeper through my own ABN?
Yes, you can. The government's been very clear that regardless of whether or not you are the business structure that you are using, if you are a sole trader, you're entitled to exactly the same benefits as somebody who had set up as a independent contractor proprietary limited and was operating on that basis. They could register because they pay wages and have employees, and a sole trader can do exactly the same thing.
Okay. Do we know when, maybe this is a Lisa one, is she around? Yeah. Do we know when the government will be making an announcement on rent relief? So is there an assumption that maybe the government will make an announcement on rent relief?
Not that I'm aware of. It would probably be state-based. And it's been floated, but I'm not aware of anything that's coming through. JobKeeper, I think, was meant to capture it.
Yeah, I think so.
Okay. Can I ask you, I'm doing some numbers in my head. I think March was a good month in real estate for agents across Australia, right? They did sales, they did deals. Yes, we had coronavirus, but they had the hardcore buyers and things were happening. What to me is a concern is, and I mean, a beautiful line. I heard a doctor say it once. He said, listen, I hear all of that, but we've learned that you should never dodge the truth. And the truth is that in April and May, I expect there to be less transactions because of everything that's happened. That says to me that come June, July, which is the settlement periods, you're going to have an impact on cash flow potentially if you haven't done anything about your cost base. Has the government provided, I know they've provided stimulus, but what are some of the stimulus that you can think of that can actually help a real estate business owner with the cash flow of their business in challenging times?
Yeah, the most of the calls that I've received over the last few days have been about the 30% drop in turnover and how I substantiate that and on what period is it based. And the comments consistently have come to me, and it's the same one that you made, which was, if I compare March 2020 to March 2019, I'm not going to show a 30% drop.
No.
What the government guidelines now say, and they updated them last night to recognise that most businesses don't necessarily have, many businesses don't necessarily have a 100% drop in revenue from one day to the next. Our real estate clients generally have lead times, particularly in the area of sales, and that can take some months for this to flow through. So the example that Treasury uses when they talk to, when they're explaining to employers about gauging their 30% drop, is they've asked them to make a forward estimate. And that's important because the forward estimate is April, May, June, or if you're on a monthly base, it's on one of those months in comparison to the same period last year. I believe that if we are in the position where we can make forward estimates, then we are going to be much clearer about whether or not we're going to hit that 30% decrease in turnover. So, for example, somebody between the period of January to March gets 50K a month, 150K a quarter in PM fees, 50K a month, 150K in sales. If they, over the next 3 quarters, April, May, June, establish that the 50K a month, 150 quarter is going to fall for the reasons that we've already spoken about to 120, and sales won't be 150 because they're just not happening to the same extent, with some exceptions, of 80K, for the quarter. Then we've hit 200K, that's the expectation. 300 was what we were comparing to last year, same time. This year we're at 200. We've already hit 33%. We are eligible to apply for the job keeper allowance.
Okay. Steve, I touched on it with Switzer, this tax rebate to employers, 20,000 to 100,000.
Yep.
In your own words, what does that mean to our business owners watching this?
Okay, so you're either a monthly or a quarterly lodger. And effectively what it means is if you're a quarterly lodger and your pay-as-you-go withholding, so your payments to employees, the tax you're withheld, if you lodged $16,000 worth of pay-as-you-go withholding for March, or you will lodge that in your March BAS, they're multiplying that by 3 to make it January, February, March, to get you up to close to the 50K limit for the March quarter. So it effectively means that if you lodge your March BAS and it shows that you have 16K worth of pay-as-you-go withholding just for March, the government will be assuming that that's what you paid in January and February. So you will be entitled for a 50K credit on your March as a result of lodging your March BAS. So if that 50K will not only cover the 16K for pay-as-you-go withholding, but it'll also cover any of your net GST liabilities as well. Any balance will then be refunded. They will then do the same process in the June and the September quarter to the value of $25,000 each quarter.
Got you.
So so most businesses or many businesses will be able to say if they're lodging if their monthly pay-as-you-go withholding is around the 16K mark or above, then they will satisfy the 50K, the 25K, the 25K relief in March, June, September, which gives them 100K that they don't have to pay to the tax office.
Got you. I've got a note here, Steve, sole trader help. For 6 months from April 27, the government will expand eligibility for income support payments, job seeker plus coronavirus supplement. Does that mean anything to you?
No, I think we're talking about the same issues that we've already covered.
Okay.
But the important point to raise is we've had a couple of clients who have come in and spoken about they're not eligible because they've only just started business in the last 12 months.
Well, I've got that question right here. They're saying I've only had business for 6 months.
Yeah, great. Okay, so what the Treasury have advised, and Treasury are releasing the policy on this, and Treasury have said that doesn't necessarily automatically cancel you from the job keeper allowance because you can't measure to the same period last year. They haven't said what criteria they will use to make an assessment. So I would urge anybody in that position to still register with the ATO your interest in being part of the JobKeeper scheme and system. And when the ATO release their criteria about the businesses that new startup businesses, they will cover off on those issues about how you seek eligibility, to the point where Treasury has said that if you cease business because of the current situation, you may well satisfy that criteria regardless of whether or not you've been going for 12 months.
Okay, beautiful. For the salespeople watching this that are going through a difficult time, they can touch their super, can't they? Yeah,
any employee can is able to obtain a $10,000 from their super fund before 30 June, $10,000 after 30 June, if they can show that they have suffered hardship as a result of a stand down or reduced hours.
Stand down, so been let go, reduced hours.
Yep.
You think a salesperson making less money?
Absolutely. Yes.
Yeah.
So a salesperson who is on debit credit and suddenly they're reduced to their $1,500, $750 a week, no longer making those sales, they should be mounting a case that if they wish to access the $10,000.
All righty. Is there anything else you want to add that you think from the stimulus packages that can be, of use to our audience here, Steve?
Sure. The one that has flown under the radar a little is state payroll taxes.
Yes.
Most of the state and territories have announced that they are either deferring any payroll tax until August, September, or in some cases, some states and territories are waiving it for certain periods, certain months.
Wow, waiving means you won't have to pay it.
Yes, correct. There are some states and territories that are doing that. I think New South Wales, for example, is saying lodge your return from March onwards, still lodge your return, but they won't be expecting payment until after September. And the same applies to the ATO, who have also said that if you are affected by the current situation financially, and you can show that, still lodge your BAS, but you can still enter into a payment arrangement, which essentially means that any payment would be deferred for 6 months and no interest will accrue.
Okay. So can I ask, in your firm, you're not just New South Wales specific, because I noticed that you've said, it changes in different states. Are you national?
Yeah, we're in Queensland and also in Victoria.
Okay, New South Wales, Queensland, Victoria, but I'm pretty certain if you had a client in South Australia that wanted advice, you could.
Yeah. So
potentially
we only do real estate agents. So we don't deal with any other businesses. We're just dealing with real estate agents. So both Greg and Steve are ex-regulator. I'm an ex-agent. We understand the industry. We get what you need to do, and we just we do it. We get on with it. We do all sorts of stuff.
A question here before we finish off, and I'm going to love it. Like Lisa, I gave you the Facebook page. It's gone pretty. There's about 200 comments on there, and there's about 60 shares, and it's got thousands and thousands and thousands of views. When you get a chance, if you get the time, sit on your mobile phone, maybe just reply back to. There might be some short answers there. We've actually put your details in the comments there. You can hit up these guys if you actually thought, hey, they feel they resonate, they feel like we can work together. One final question: commercial tenancy, whilst we can't evict, can we still lock out? Tenant refusing to pay rent, not negotiating, yet continues to trade commercial lease.
I'd be very wary of locking a tenant out, even a commercial tenant. I would suggest that, and with a view that a commercial lease will have been done by a solicitor at the beginning, I would say to that agent to recommend to that landlord to have that solicitor have another look at it. And my concern would be not only just getting the legality checked of it, because there are certain notices that have to be issued, for example, under the Conveyancing Act in New South Wales, but you don't want to be the one on a Current Affair or one of those shows at night with a camera crew filming your agency locking someone out in the current climate. So let's just keep it perspective. I would flick it over, get the solicitor to have a look, make sure the right notices have issued. I'd also just be mindful, as I say, for the media and reputational interests of the agency.
Okay, look, the tone I'm getting out of this conversation from Lisa is, hey, work with people for cash flow. Don't throw the sink out. Don't think to yourself, this all means that it's holidays for people. And the tone I'm getting out of Steve is, we've got a government that is actually got an intention. They want to work with people. They want to work with an employer not to go down. They want to work with a commercial tenant to try and keep trading. And they want to work with a boss to keep their staff on. So their intention is there. And essentially, whenever you're doing any of your correspondence to, the government for any of these allowances, put your story there. And I'm sure that they're probably going to be on the compassionate side this time around.
Yes, yep. The government has indicated that to be the case at various levels of government.
Okay, I'm going to ask you, this is just a fun thing to finish off with. When do you think the pubs, the restaurants, and the football stadiums will be full again? Have a punt here.
I'm optimistic. I believe some of the measures that we've put in place may well ensure that it's a June, July discussion rather than September, October.
Yeah, I'd like to think it'd be June or July. I don't know. I think everyone's doing the right thing at the moment. People are quarantining and, you know, everyone's chipping in. If that continues, except for us, then hopefully, yeah, June or July. Let's see.
Well, keep your fingers crossed. I've got to tell you, there's a different tone in the last 72 hours. I actually think 3-4 days ago, I don't know, I thought to myself, hey, you know, we're about to have some bad stuff happen in the next week or two. And then all of a sudden we got some news that the explosion wasn't happening at the rate. And I got to tell you, it's bloody great being an Australian in Australia when you look at the last 3 days. For some reason, you just feel, hey, you know, things could be so much worse.
Yeah, very much.
Yeah, that's right. That's right.
All righty. Thank you so much. I know it's late. I know you've gone into the office, but you're good friends to the real estate industry, and I'd love to have you back on sometime in the near future.
Awesome. Okay, thanks,
healthy.
Tom.
Thank you.
Okay.
Thank you.
Bye.
Bye-bye.